This is cause number 328262. The case is style of State of Texas versus Steve Johnson or Stephen Johnson. Um, For the record, we have Mr. Johnson appearing via Zoom. Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Mr. Johnson, you may put your hand down. Now, Mr. Johnson, you're represented here by your attorney, Mr. David Grove. Mr. Grove is appearing in court.
Oh,
If you look on the monitor, you'll be able to see him waving. Okay, now, and the state is represented by Assistant District Attorney, Ms. Julie Maxey. Mr. Grove, how are you doing?
Good, Judge.
And Ms. Maxey, how are you doing?
Doing well, Your Honor.
That's good. Now, Ms. Maxey, I have before me a motion to appoint a psychologist or psychiatrist. Did you receive a copy of this motion?
I did, Your Honor.
Okay, now, pursuant to the Texas Code of Criminal Procedure 46B.004, we will be conducting an informal inquiry to determine whether or not there is some evidence from any source that would support a finding that the defendant would be incompetent to stand trial. Now, also pursuant to Article 1.24 of the Texas Penal Code, the proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed
it's trespassing.
proceeding rights or interests such as interest in
Excuse me, sir.
preventing disclosure of non-public information or ensuring that the defendant receives a fair trial. Mr.
I'm not
Grove,
going to trial with this, sir. This is trespassing.
is Mr. Johnson
Yes, sir.
requesting that the hearing be closed to the public?
Your Honor, I'm not aware of that. I believe.
I'm
that's
not
in court right now.
I'm not going to trial, sir. This is trespassing. That's all I have.
I understand that.
You know, because I'm an alleyway guy in the National Longshoremen Association. I work for a living. That's all. I'm trying to go ahead and get time served on this so I can get out of here. I don't need a lawyer for this.
Okay.
So I can go get my body checked on because I got hurt on my job a while back, and I'm on heavy narcotics, and I got ear problems too. I'm trying to get time served for this trespassing.
Okay, we understand that, Mr. Johnson. So, Mr. Grove, so we will continue to keep the proceedings public.
I have no objection to that, Judge.
Okay. Now, let's see. Now,
I'm not trying to take no trial on this. I'm trying to take time served for this trespassing. I've been in 28 days. You know, that was the offer last time, and you know, you had redone some things, sir. They got me in the back for no reason, but excuse me for interrupting.
okay, so now, Mr. Johnson,
Yes, sir.
let me, the court is trying to proceed.
I didn't even know, but can I speak, sir?
No, not at this time.
Yes, sir.
You'll have an opportunity. Now, Mr. Grove, pursuant to Article 46B.004, we must consider the factors that are in 46B.024. And so we will proceed as follows. Now, Mr. Grove, you had an opportunity to talk to Mr. Johnson.
Yes, sir.
And during your conversation, did Mr. Johnson have the capacity to rationally understand the charges against him and the potential consequences of the pending criminal proceedings?
I thought he did, Judge, until we got before the court for the hearing. And then that's when his behavior and his comments made me believe that he did not have the competency to proceed at that time.
Okay, was he able to disclose to you?
Talking about
He-
conversation. He got me in the back for no reason.
Or of his state of mind?
I thought he was, Judge, but again, he began speaking before the court. I believe he did not have that capacity. I thought he did it first when we signed the plea papers and that type of stuff. We came before the court for the plea, for a time served plea as he wanted.
Yeah.
And that time, he seemed to have indicated that he was not understanding what was going on, what he was charged with, and being able to assist counsel. Meaning,
Okay, did he understand the adversarial nature of criminal proceedings?
at first I thought he did, but I don't believe he did, Judge. After we heard.
I take medicine for this ongoing injury.
Okay, do now is there any evidence to support any indication that the defendant's personal history is whether he's a person with mental illness or a person with an intellectual disability?
I believe conduct while he was in court before this court, he indicated he did not, or he did have some intellectual problems and some mental history.
I work for a living. I work for the Board of Honor.
I don't believe he understood what was going on.
Okay, now let me ask you this here. Do you know whether or not your client is taking any psychiatric or other medication, whether the medication is necessary to maintain the defendant's competency, and the effect of any of the medication on the defendant's appearance, demeanor, or ability to participate in the proceedings?
Mr. Johnson indicated he was taking narcotics, drugs, although my personal belief is that they would not allow those type of drugs while he was incarcerated in the Jefferson County jail. So he indicated he was, but I don't think that he was.
Oh, that's prescribed medication, sir, for ongoing work injury. I'm trying to figure out, what's really going on. I really didn't need a lawyer for it because, I was on that property when the lawyers had called to ask for my identification. So I walked up on it. So I was trespassing at the time. I work for a living. I do not know what they're talking about, psychotic or nothing, but that's my ongoing injury my medicine for my ongoing injury for accident, industrial accident. And my doctors and my lawyers and things, my lawyer's in Houston, actually, he can verify everything what's going on. I don't take psychotic medication, no sorts, sir. This was a trespassing that I was trying to get, time served for. I'm trying to figure out what's going on. I got medicine for my ears that's in my property. They've classified me in red for what reason. I wasn't being combative in here. I normally be in a working type of place because I wake up early in the morning like work people do. I do not know. I don't know why I even have a lawyer actually, because the lawyer that I have is a injury lawyer. I didn't need a lawyer for none of this. This I already know it's a Class B misdemeanor, which I could have done like time served for this. I could have bonded out actually. I stayed there 28 days, and I don't want to waste any more taxpayers' dollars, which that's mine too.
Okay, you have anything else?
No, Your Honor, I believe the court can see the problem I have in communicating with Mr. Johnson.
Okay. State, Mr. Johnson, you have anything else? You have anything else that you would like? Mr.
Well, I'm
Johnson?
trying to see what's going on, sir.
Okay. Mr. Johnson.
Yes, sir.
Your attorney, Mr. Grove, has filed a motion here, and the motion is to appoint a psychologist or psychiatrist That's what the motion is, and the court is conducting what is called an informal inquiry to determine whether or not there is some evidence from any source that would support a finding that the defendant may be incompetent to stand trial.
Well,
So
sir,
that's
I'm not, sir, I was never taking this to trial.
Now,
I was never taking this to trial, sir.
okay,
See what happened, I don't know what, maybe we had a misunderstanding. I never was taking this to trial. I don't need to take this to trial. I need to go ahead and finish up my business. I have a doctor's appointment on September, actually, and I'm not trying to take none of this to trial. And psychology evaluation, I'm classified, they classified me back here for what reason, I do not know, which I be in blue, working, whatever, get up at a certain time like they normally do. I need to go, get things situated with me.
Your Honor,
yes,
at this time, the state would move for a dismissal in the interest of justice so that the defendant can be released to mental health services.
okay. So now, are you going to file a written motion on that?
Yes, I am.
Okay, well, this will conclude this hearing. Mr. Johnson,
Yes, ma'am. Yes, sir.
the state it has stated that they'll be filing a motion to dismiss this case.
Yes, sir.
Okay.
So I'll be released today.
If nothing else
Well,
is holding you,
yes, sir. Yes,
so if
sir.
nothing else is holding you in, the state is filing a dismissal on this case. Okay. So
Yes, sir. Should I be released today, sir?
follow the bailiff. I mean, if you need some time to talk to your attorney, you can. But if you do not, you can just ask the bailiff to come in and then follow the bailiff. This will conclude your case, and you'll be free to go, and you have a blessed day.
Yes,
Okay,
sir. Thank you. Thank you, sir.
You
You have a blessed, wonderful day too, sir. Oh.
All right.